Well, hi there, everybody. Good afternoon or good morning if you're joining us from BC or Alberta. My name is Sephton Leibbrandt. I'm an associate here at Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you, everybody, for joining us this afternoon or this morning for another of our regular installments of this great 30-minute Q&A session here. So while we wait for some of the kind of comments to roll in, or questions, I suppose, to roll in, we'll just talk about some things that are kind of in the news of late. So, of course, on everybody's mind at the moment is the ongoing trade tensions between, unfortunately, ourselves and the United States of America, and the issues surrounding that, and how that's affecting, of course, our economy generally speaking, and the job market, in Canada, and especially in Ontario, Alberta, and BC, amongst other places. So if, for instance, you are located in Ontario, one thing that is sort of relevant recently, as if you may be an employee or former employee potentially of ON Express, which is a corporation that is involved with GO Transit and Metrolinx, maintaining their services and facilities and their operations. A number of these employees, unfortunately, of late have been terminated from their employment. So, a general question, and one that is, the most common that we always receive is, if I am terminated from my employment, it typically as a result of, restructuring or economic issues, shortages of work, what am I entitled to, at law? And that is, a very important question. Generally speaking, anybody who's terminated for those particular reasons, restructuring in the workplace, shortages of work, and things like that, you would be entitled to, a severance package, generally speaking, under the common law, unless, of course, your employer has with you a contract that effectively holds you to the minimum entitlements under either the Canada Labor Code or the Employment Standards Act, depending on whether you are a provincially or federally regulated employee. And most people are provincially regulated employees. The only kind of exception is if you, happen to fall under the certain sectors like interprovincial trucking or banking, certain resource extraction things, and other kind of sectors that are federally regulated, aviation being another one, but not very many. The vast majority of people are, again, provincially regulated employees, and as such, you're governed by the Employment Standards Act. So in terms of what your severance package would look like, generally you look at, first one's age, next one's years of service, and then your position, depending on whether you're a manager or non-manager, the greater one's age, the longer one's years of service. And if you want to, a manager and a more senior manager or an executive, generally the longer that severance package for that person needs to be under the common law, potentially up to a maximum of 24 months of compensation from your employer. So of course, if you have any concerns about your severance package that you received, this is an initial kind of thing that you can do. It's a good first step. You can go to our website, employmentlawyer.ca, and use the severance calculator there, and just kind of get an initial formal assessment of what potentially a correct severance package for you would look like in the circumstances. And generally speaking, the vast majority of employees I come across, the initial offer from the employer in terms of what's given on offered upon termination is usually not nearly close to what somebody's actual legal entitlements are at common law. Usually the packages I see are grossly deficient, for the most part. So very important to get that initial assessment there to see, where exactly are you on that scale? Is your package, fair and reasonable? Or is it, like most people, usually it's quite unfortunately, deficient in the circumstances. And that's where we're happy to help. So now I see a bunch of questions have rolled in here, which is great. I see one from YouTube, from Kino Keefe, looks like, has asked, I've been working on my job for 15 years and I am planning to retire. How soon should I give my retirement notice to my employer? Thank you. So if you're planning to retire, number one, generally, so you understand, you are not entitled to a severance package if it's in fact, your actual intention to retire. Basically retiring or resigning, the same notice would typically be required. There's no hard and fast rule, but generally speaking, 2 weeks of notice is sufficient, for the most part. You don't need to give sufficient, significant notice, generally speaking, in the circumstances. Sometimes if you wish to do so, you can give more than that, but really it's not necessary at law. But of course, the great issue becomes, if you are intending to retire, to resign, is that the employer is not then obligated to provide you with a severance package of any kind. You're resigning or you're retiring, and that's that. A severance package, and the purpose of a severance package is simply to tie you over from one job to another comparable job. And if there's going to be no, comparable job there in the future, then unfortunately, there would be no entitlement to a severance package, by the same measure. So that's something you should kind of consider, after 15 years of service. Perhaps you can discuss with the employer if there's some kind of mutual arrangement where you can obtain some kind of package. But generally speaking, if you're just going to retire or resign, no severance package will be owing to you from the employer if you do so. You're only entitled to a severance package if you are terminated from your employment, and typically it would be without cause termination. So if you have a follow-up question, I'm happy to answer it, but thank you for that question. Hopefully that answers your concern. If anybody's joining us here, again, I am Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP, and we are the employment lawyers answering your questions here today on this 30-minute regular installment of our Q&A. So thank you, everybody, for joining us this afternoon, this morning. Looking for some more questions, waiting for some more to roll in here. So look, another question from YouTube has come in. This person has asked, I was let go from my job yesterday, but I was on a medical leave. They offered me 10 weeks and extended health benefits, but I'm wondering what I should do and if they're allowed to let me go like this. I worked there for 5 years, almost 6. So, that to me sounds to be, a very grossly deficient, severance package. 10 weeks would be, not even 2.5 months, would be under 2.5 months of notice. It would just be over 2 months of notice in the circumstances for somebody who is, there for 5 years, not considering other factors, and, assuming there's no contract that's involved, then, legally speaking, probably, minimum, notice period would be on the order of about, potentially between 6 and 10 months, depending on, your full circumstances there. And that would depend largely on, your age and your position at the company and rate of pay and things like that to get you higher into the range, higher, close to that 10-month period, for instance. But clearly 10 weeks is not even close in the circumstances. It's grossly deficient. And so, that on that part of the question, that's an issue there. On the part about the medical leave, well, that may be another issue as well. An employer who terminates somebody on a medical leave, naturally the optics will suggest that that particular person is legally entitled to potentially human rights damages if the termination was not legal, or even based partly on the medical leave of absence and the circumstances. So that may be another serious factor to consider as well. That may be in addition to any kind of severance package owed by the employer. If you're terminated on a medical leave of absence, there's always going to be the concern, for obvious reasons, that the termination was based upon potentially in part or in whole your medical leave of absence. You generally don't see it very often. Typically employers are smart enough not to terminate when someone is on a medical leave of absence, unless there are extenuating circumstances with the employer themselves, perhaps if they are seriously having serious financial difficulties. Otherwise than that, very atypical that you see an employer terminate somebody while they're on medical leave for exactly the fact that in addition to a severance package, there may well be a legal entitlement there to damages under the Human Rights Code of Ontario, for instance, or the Canadian Human Rights Act potentially as well. So thank you for that question. But no, of course, this is not an uncommon situation at all where you see, a very, very grossly deficient severance package, a matter of potentially, weeks instead of months towards one's severance package. That's a great issue. 10 weeks on almost 6 years of service, it's not even close to sufficient the circumstances. And of course, a helpful pop-up there below is that if you are, interested and you've been terminated of late in determining, whether just on a rough basis, the severance package offered to you is, sufficient or correct, absolutely go to our severance calculator and have a look there and just fill in some very basic information. It's basically entirely anonymous, and calculate how much roughly you may actually be entitled to, and you'll typically be surprised that it's actually significantly more than typically what the employer has offered you in the circumstances, because of course the employer is looking to get out of the termination of your employment with the best possible deal for the least amount of money, as one can expect in the circumstances. So thank you very much for that question. Just waiting for some other questions to populate here. For joining us this afternoon, I'm Sephton Leibbrandt, an associate with Samfiru, Tumarkin, LLP, and we are the employment lawyers. So I see some more questions have populated here. So another question looks like from YouTube has asked, if your employer uses AI to monitor employees' performance, can they use to fire you for cause? How a reliable or AI decision? Okay, so this is certainly a very contemporary aspect of the workplace in modern times here. Not something that you would see very often at all. If your employer, and we're of course going in this direction, if your employer is intending on terminating you based on potentially performance issues, there's a very, very high bar to meet. Number one, to establish just cause. Just cause means serious misconduct. Basically, it means that the employment relationship cannot continue any further. It's basically irreparably broken, and because of the conduct that the employee engaged in, and as a result of that, you've been terminated for that basis. Even if you're terminated for just cause, though, potentially, if you are provincially regulated, so anything not banking or interprovincial trucking or aviation or mining or things like that, things that are or telecommunications as well. Other than any other profession or industry, other than that, if you're under the ESA, the employer actually needs to meet a higher threshold than simply just cause to withhold what are your minimum employment entitlements upon termination under the Employment Standards Act of Ontario. And those particular entitlements are, can be significant potentially if you are working for a larger employer, for instance, and if you've been there, of course, for a number of years, you'd be entitled to potentially both termination pay, which would be about 1 week per year of service, and then additionally, statutory severance pay, which is an additional 1 week per year of service, up to a maximum of 26 weeks. So both of those added together can be, potentially up to about 8 months if you've been employed for a very, very long time. So that particular threshold, that higher threshold called willful misconduct, extremely, extremely difficult to meet. Basically, you need to have engaged something called being bad on purpose. Effectively, the employer needs to demonstrate that the conduct you were engaging was intentional and deliberate, and effectively trying to harm or prejudice the employee's operations. A very, very difficult threshold to meet. So as long as you've not engaged in that very, very serious type of misconduct, deliberate misconduct, then even if the employer terminates for just cause, you'd still potentially be entitled to your minimum statutory entitlements under the Employment Standards Act for the most part. So, an interesting question, a very good question in terms of, Performance allegations, again, generally speaking, performance allegations are never sufficient to establish even just cause for termination. The employer really needs to have done, their due diligence. There needs to be, a lot of progressive discipline, a lot of, retraining efforts and things like that, coaching efforts documented with the employee. And it basically needs to demonstrate that they are, effectively incompetent in their profession and in their job in order to permit termination for just cause for just simple, performance allegations. So a very, very hard thing to establish. And generally speaking, whether AI would affect anything, perhaps probably it would, because it would only be the suggestion that it would even be less reliable in terms of the decision that was made to terminate in the circumstances. So long and short of it is, if it's termination for just cause based on performance, very unlikely that that's going to hold up at law. So thank you very much for that particular question. So I see some more questions are populating here, which is wonderful. Just going to adjust my camera there for a second. So let's see some other questions here. So it looks like we have another question from YouTube. Looks like a Giblet has asked, my employer is picking up work a good distance outside of our immediate area. They sent a company email stating that they will only pay for travel one time, one way. They said that they can either be commute to the site in the morning or commute home. The last 2 weeks, it was taking me 2 hours to get back to my shop on my own vehicle. Did they pay for mileage? Is it legal to deny me hours for driving? So generally speaking, the employer always needs to cover, well, it depends on the nature of the distance being traveled. Usually the commute time is factored in as can be potentially factored in the circumstances. It really depends potentially on the distance that's being asked. Looks like 2 hours, of course, that would be very significant. If it was 2 hours one way, that would be very, very significant in the circumstances. It ultimately may come down to, unfortunately, Giblet, whether if this is really a suitable position, if it's that far away from you. Because usually, and generally speaking, if this is under the Employment Standards Act, then commute times are typically not, considered as working time, for the most part, unless it is to, to get to, a certain particular area, like for, if you're going to drive to a client or something like that, for business or for work purposes. If it's, construction, for instance, to drive to the construction client. If it's for that purpose, then those, kind of allowances, that traveling time is typically actually considered to be, hours of work. So you're supposed to be compensated for that. But commuting to and from the office, it's generally not considered to be, actual payable time, payable hours. So unfortunately, maybe the circumstance you need to determine, is this, the best position, the best fit for me? If they will only, pay travel time one way, if they're not going to pay, both ways, there's no legal requirement, unfortunately, in the circumstances for them to pay for that commute time at all. So if they're only going to pay one way, the question becomes, are the wages otherwise kind of sufficient in the circumstances in that job to make it worth the while, to make the work still make sense? And for the most part, that's generally the case, that the wages would still be sufficient even if they're only paying one way. But unfortunately, yeah, it's a very good question. It's not a question that comes up very often, but commute time to and from a workplace is generally not considered to be payable and workable hours, and so the employer has no obligation to compensate you for those. They're only required to compensate when the commute is actually required. It's essential to the performance of your job effectively, or performing your business on behalf of the employer. For instance, if you're in a construction, you have to go around to a bunch of construction sites. That would definitely be a case where the employer would probably be required to compensate you for traveling between the construction sites, during your day, as part of your workable hours and payable hours of work. So thank you very much for that question. Very, good question. Not one that comes up very often, but unfortunately, long and short of it, employers do not need to pay for commute time under the Employment Standards Act, for instance. So again, thank you everybody for joining us this afternoon. Just waiting for some more questions to populate here. Again, I am Sephton Leibbrandt, and I'm associate at Samfiru Tumarkin LLP, and we are the employment lawyers. And thank you everybody for joining us this afternoon or this morning in this 30-minute live Q&A. So I see some more questions rolling in here. Looks like one from YouTube. Rob has asked, I was fired by email with no explanation on the weekend. Very political and difficult environment with lots of turnover. I was employed for 6 months. I was given 4 weeks of pay. Am I entitled to more? So that would largely depend on the type of position that you were in, for instance, the rate of pay of that position, and the level. Is it a management position, non-management position? Potentially, 4 weeks of pay sounds to be insufficient in the circumstances, even for very, very short-term employment of 6 months. But it would really, a significant severance package, of a number of months would probably only be owed, if this is a type of job or profession where it is unlikely that you can find comparable work in the near future. If this is a job, for instance, if this is truck driving, for instance, where there are lots and lots of those jobs typically available, in that circumstance, technically speaking, you may have, entitlement to a greater amount of notice than 4 weeks. But in reality, you can probably find another job in a month. The amount of time the employer has offered you here, 4 weeks. If this is a job other than potentially, in truck driving or in construction, for instance, where jobs are less plentiful, then in those circumstances, probably for 6 months of employment, again, this would depend, significantly on, the nature of your position and your rate of pay. Probably a severance package between, I would say, 2 and 4 months of notice would be owing in the circumstances. And that's, of course, okay, so you've added some more context. Thank you. No contract, it's a professional job, $80,000 a year. Yeah, no. So a job like that, 4 weeks of pay would not be sufficient. Probably your severance package would be on the order of about 3 months of pay there. So the 2 months or the 4 weeks has been provided. Obviously, less than a month is not sufficient in the circumstances. Very, very inadequate to some degree there. And of course, it could potentially be longer. It would largely depend on, again, the type of profession that you are in the industry, and the availability again of comparable employment, because that's really what your severance package is all about at the end of the day. It's about how long is it generally going to take you to find other comparable work. In the circumstance, the law will probably say about 3 months. But if it's a different type of industry, it could be potentially longer than that. If it's more specialized, if it's management, not mention that it's management, but if it is management, of course, that would suggest a longer notice period in circumstances. In either event, definitely something you should reach out to us to assist with. And you can, of course, find our information on employmentlawyer.ca. Happy to, of course, go over with you a more thorough and detailed analysis of this particular circumstances. But 4 weeks, as I've said, not sufficient, from my perspective, in the circumstances. And of course, you said there's no contract. Or no ESA mentioned in the contract. But again, definitely something we want to have a look at there, just to make sure to cross the I's and dot the I's and cross the T's as it is. So feel free to reach out to us there at the link provided below. Getting some more questions in here. Thank you for that question, Rob. Looks like Jay has asked, I've been with the company since 2010. Some others have been there longer. Perhaps is the second part of the question coming. So 2010, obviously, so you've been there for about 15 years, maybe 14 years. So obviously a significant amount of time. I'm not sure if there's another part of the question, Jay. Oh, there potentially is. Employer starts reducing your hours and using younger and cheaper labor to fill the work that would have come to you. Is that constructive dismissal and a severance? Oh, yes. So generally speaking, and it would depend largely on the reduction of hours. how we kind of look at this, Jay, is from sort of a rule of thumb standpoint. If the reduction in out of hours would result in you know, receiving 10% or less, 10% of your pay, for instance, or less, reduction of 10% or more, sorry, I should say, then in those circumstances, generally speaking, you may have an argument for constructive termination there, constructive dismissal, the same thing. The greater, if it's 20%, 30%, reduction in hours, things like that, that becomes potentially a very, very clear case of a constructive termination in a payment of a severance package, typically flowing from that. So this is definitely a situation, again, where you'd want to reach out to the firm, especially after sounds like about 15 years of service, to have a more thorough kind of look at your circumstances there. So you can see the kind of the link pop up there, employmentlawyer.ca. Feel free to reach out to us there. We always have people standing by to assist you with these kinds of things in more detail, just to see the documentation here, if there's a contract, things like that, and have some more details on the extent of this reduction in wages. Because if it's a significant reduction, 20% or more, becomes potentially very apparent that you've been constructively terminated and you're potentially owed significant severance package after 15 years of service. So that's looks like about all the questions for today. So thank you everybody for tuning in with us. If there's other questions that pop in a moment or two here, I'll answer them, but it looks like that's all for this afternoon. So we will be live again at 1 p.m. tomorrow on Wednesday with our co-founding and managing partner, Lior Samfiru. So thank you everybody for joining us this afternoon, and have a great rest of your day.